This matter is as complex as it is simple. Who is the clerk? Is it the clerk who swears an affidavit in the governor's statement? Is it the clerk who swears an affidavit in support of the impeachment motion? Mr. Speaker, it is the position of the County Assembly that the governor captured the clerk. That is a matter of evidence, and that is evidence that we want to lead. When I said we want to cross-examine the clerk, it will become apparent when you listen to that testimony that the governor captured the clerk, and the clerk, for all intents and purposes, became a saboteur to the impeachment proceedings. You will see in the governor's clerk statement, a statement where the clerk says, "I cancelled the public participation." So that is what I meant. It is important that the Senate enables this motion to get to the point where the evidence is laid before you, and you can then make up your determination about what happened, who captured who did not capture who. And it is the Assembly's position that the governor cannot capture the clerk and then hold the clerk and say, because there was no clerk, there can be no impeachment. It is apparent in law. You cannot do things like that and seek to benefit from them. So therefore, this motion must then get to the point where evidence is laid. Senator Manzo, what is our rebuttal to the points given? I had stated that a preliminary objection is, in our humble understanding, an issue of law that is raised. There are several factual rebuttals, but we as counsel, in the privileged position we occupy, are unable to testify. Our witnesses have rebutted those things that counsel have said, and it is therefore vitally important that this motion gets to the point where the Senate can hear that testimony from the witnesses themselves. We say, yes, there were sittings that took place, and we have said further that from the conduct of the governor who took those proceedings to court, they acknowledge that the assembly did take place. There is an affidavit from a senior superintendent of police in Isiolo who says that he went and the proceedings in the assembly were disrupted. Surely the Senate must hear from that superintendent of police. We have cross-examination to put to him so that you make up your mind about what happened in those proceedings, who sabotaged, who took place, who took part, and so that you can make up your mind. Yes, it is complex and simple at the same time. Senator Karungo, do we have audio and video of the Hansard of the day? I will allow my colleague to respond to that question. Senator Ojenda, Senior Counsel, sittings were the basis of the orders obtained in Meru. Yes, we allege that there is an estoppel. Was there a sitting? Yes, there was a sitting, and that is why there is Hansard that the governor's advocates seek to now criticize at the preliminary stage. If there were no sittings, there would be no Hansard. And if there were no sittings, there would then be no foundation for the governor's advocates to go to court in Meru on the 25th or the 26th of June and get the orders that they did. That those orders exist from where we sit is proof that those sittings took place. Senator Mungatana, has the Meru decision been appealed or stayed? Our position is that in respect of impeachment proceedings, the Supreme Court in the Martin Nyaga Wambora matter gave guidance, not just to courts below, but to county assemblies and to the Senate, as to what to do with orders that are issued, like the ones that were issued by the High Court in Meru, in respect of incomplete impeachment proceedings. Those orders, according to the decision of the Supreme Court in Martin Nyaga Wambora, can be, I think the wording used by the Supreme Court is that they cannot be, they should not then be immediately effected. And that is the guidance that has been given by the Supreme Court. Senator Cheralgei, how many clerks? I believe I have attempted to answer that question. Yes, there is a question as to how many clerks there were and who was the clerk, but that is a matter of evidence. They have their position about who the clerk was. We have our position about who the clerk was. As I have said, it is our thesis that they captured the clerk. But the assembly needed to continue, and that is a matter of evidence that will then need to be tabled. As an advocate, I am unable to testify to it, but I know those affidavits exist in the record. Who invited the army? Like I said, in the governor's documents, there is an affidavit by a senior superintendent of police, and it is apparent that if he is swearing an affidavit for the governor, then the answer as to who invited the police or the army is answered by the fact of who is the police or the army testifying in favor of. Was public participation done? Yes, public participation was done. Was public participation done in disregard of the court order? I want the answer that I have given in respect of Senator Mungatana's question as to what should be dealt with court orders of the nature or of the species of, that was issued in Meru in respect of these impeachment proceedings to also apply to this, to that issue. Senator Wambua, is this the official Hansard of the recording proceedings? I will say yes, but my colleague Mr. Mawira will come and deal with that issue in more detail, and he will explain to this House as to why those are the official Hansard reports in respect of the proceedings. Senator Sigei, the ruling of the motion was the ruling that the motion was of no effect. Is that the motion before this House? Yes, it is. And I would urge this House then to consider that ruling in respect or together with the ruling of the Supreme Court or the guidance of the Supreme Court as to what should be done with rulings of that nature. And if I may state during my response to the questions from the senators, if this House stops this impeachment proceeding in respect of a court order like the one that has been issued, then as an advocate who has practiced law for not an insignificant time, I can say without any fear of contradiction that this is the last impeachment that this House will do, because the courts will then, the court orders will delay and delay and delay. There is a good reason why the Supreme Court took the position it did in Martin Nyaga Wambora, and there is no reason to depart from that position. There was a question as to whether the Hansard is full or abridged. Do we have an audio recording? Again, my colleague, Mr. Mawira, will respond to that. Senator Halwale, no response to the allegation that the documents were cooked. That is an issue of fact. And because it is an issue of fact, it cannot fall from the mouth of the advocate that the documents were cooked. That can only come from a witness. And from our corner, it can only come from our witnesses. That is their position. We have an answer, and it is in the response, or it is in the documents that are brought in support of the motion. It is not an issue, because it is an issue of fact, it is not an issue that can be brought forward and tried as a preliminary issue, as the legal team for the governor seeks to invite this House to do. That is an issue, and it is a contested issue in the motion, and I beseech this House to allow the motion to get to the point where those who are competent and capable to testify to those contested facts are able to do it. In respect of the order, or in respect of the finding, Senator Halwale, again at page 23 of volume 4, again I will repeat my answer to that question. This is an order, the species of which was envisaged by the Supreme Court in Martin Nyaga Wambora. Compliance does not need to take place. It doesn't need to take place immediately. And the Supreme Court then is clear that such an order, when issued by the High Court, should not and cannot get in the way of impeachment proceedings. The High Court's jurisdiction only arises once the impeachment proceeding is complete. When I was on my feet earlier on, I made the statement that what the Supreme Court envisages is an instance where even where the impeaching House is making a mistake, allow them to complete the mistake, because that is how institutions grow. And that is why the Supreme Court held as they did. Again, I will emphasize that these are time-bound proceedings, and if we then expose ourselves to the judicial process, we will never finish. Senator Mudama, clarify if there were sittings on the 18th and the 25th of June 2025. Yes. And that is the only way that the motion could have gotten to the Senate. My colleague will demonstrate by reference to the Hansard in the evidence in support of the motion when and how those proceedings took place. Would it be in order for the Senate to proceed against a court order? Mr. Speaker, I will ask to perhaps add a word in the question that was put to us by Senator Mudama, will it be in order for the Senate to proceed against an unlawful court order? We have gone to great lengths to demonstrate that that order is unlawful, it is made without jurisdiction, and it is made in circumstances where it is clear and there are binding pronouncements both of the Court of Appeal and of the Supreme Court that that court disregarded, that that court's jurisdiction only arises upon the completion of the impeachment proceedings. Those proceedings have not been completed, and that order is therefore to be ignored. I cede the rest of my time to my learned colleague so that he can cover the other important issues.